Well, good morning, and thanks again for being here this morning. It's really great that you chose to spend part of your Saturday morning to talk about guardianship, because I know there's nothing I would rather be doing. No, but really, thanks for being here. This is a really important topic, and there's a lot to it that, what did I do? There we go. There's a lot of stuff that goes along with a conversation about guardianship and guardianship reform in Texas. So we're just going to touch on lots of different things. We're not going to get into a lot of detail. However, you should have my contact information on the presentation there. And so after this morning, if you want to stick around, I'll stick around and answer questions if you have any, or after you've had a chance to think about things, always feel free to email me or call me or whatever. I'm always happy to talk about this stuff. Before we get into the meat of what's going on this morning, a couple of things you should know. Number one, my name is Jeff Miller, and I do work for Disability Rights Texas, which is Texas's protection and advocacy organization for people with disabilities. I am a recovering attorney, having been in private practice for a number of years, but now I do a lot of work with our state legislature and our state agencies, looking at systems for people with disability and trying to figure out how to make those work better. But most importantly, I think a thing that you need to know about me is I'm also the very proud father of a 21-year-old with IDD. And so as we talk this morning about choices and decision-making and guardians and alternatives, it's something that not only do I work with professionally, but I get to live that every day. So hopefully they'll give me some insight to relate to questions that you might have, and let's get started. So when we talk about guardianship, where we have to start is the concept of self-determination. And you might think to yourself, what does self-determination have to do with the laws around guardianship? Well, they do, in that self-determination is something that is really important for all of us because it starts with rights. See, because we are American citizens and we're Texans, we have certain rights, right? We have laws, we have constitutions that give us rights. And if I have a right, that means I have choices to make. Because of those rights that I have, I get a chance to make choices about what I do with my life. And self-determination is all about choices. Self-determination, when you think about it, is really that idea of, do I have any control over what's happening in my life? And if you think about it, think about your own life and think about when you feel like you have control or you feel like you have some say in what happens to you, you feel a whole lot better about yourself, don't you? Research tells us that people that feel like they have some control over what happens in their lives are happier, they're healthier, they're more likely to be employed, and those sorts of things. Whereas if we feel like we have no control over what's happening to us, we tend to get depressed, we tend to get detached, and things don't go as well. And that's why when we're talking about individuals with significant support needs or people with disabilities that we may consider guardianship for, self-determination becomes really important. Because we know, both from our own life experience and from the research, that self-determination is a good thing because it makes people feel better and makes them more productive in society. We also know that that's a good thing to promote. And as an advocate for people with disabilities, I'll tell you that we all believe self-determination is the way to go and we're all supportive. As a parent, I will tell you, I am very supportive of my son making any choice he wants and all the choices for himself that he wants to, unless I don't agree with them. And that's sometimes becomes an issue. See, as parents, we really love our kids, we love our loved ones, we want to take care of them and protect them. And so sometimes, although we want them to be happy and we want them to do whatever they want to do, if they're going to make a decision that we think might not be in their best interest, that's hard to let happen sometimes. Although Now, this whole concept of dignity of risk really is important. Dignity of risk says that sometimes it's worth it to allow someone to make a decision that may be a poor decision, but that's how we learn. It's also part of that concept, if we really believe in self-determination, my right to make decisions shouldn't be contingent on the kind of decisions that I make. In other words, it's okay to screw up. People do it every day. I raise my hand. Those things happen. And so self-determination and thinking about that is really important when we get to the idea of guardianship. So what is guardianship? Well, guardianship is that legal process where the court determines that someone is not able to take care of themselves, so they appoint someone to take care of them, right? And so why do families think about guardianship and why might it be appropriate? Well, there's lots of reasons. And actually, before I get into the reasons for guardianship, let me say something. When we're talking about guardianship this morning and these alternatives and whatever, it is not the position of Disability Rights Texas that no one ever needs a guardian. Because obviously there are people that have significant support needs, and in some situations, a guardian is the only appropriate way to meet those needs. But it's also not true that everyone that has significant support needs or a specific kind of diagnosis, like intellectual disability, not everybody that has ID needs a guardian. There are other ways to help people meet their needs and get the support that they need in their lives, short of taking away their rights through a guardianship proceeding. So when we think about guardianship, lots of reasons I hear from families that they're considering guardianship for their loved one with support needs is financial exploitation, one of the biggest, because we're all afraid that our loved one's going to be taken advantage of. And so we hope a guardianship will help with that. And while it does provide some protections, it's not a panacea. People under guardianship get taken advantage of. Other things can happen, and there's other ways to help meet someone's need to take care of their finances. But it is something that people consider. Another reason that families look at guardianship is that they believe, especially if they have a loved one that's in special education in public school, we all know that when someone turns 18, the parental rights to make educational decisions transfer from the parents to the adult student. Lots of parents are concerned about that. And so they really believe that guardianship is a way to continue to be involved in their child's educational decision-making. And while guardianship does allow that, there are other ways for families to continue to be involved after someone turns 18. Guardianship isn't the only way. People also consider guardianship because they believe that it's a way to get access to long-term services and supports or other kinds of programs. And once again, one isn't really tied to the other. I think one of the biggest reasons that people spend a lot of time looking at guardianship is because they don't really realize that there are other options and what those options are. And so my job for the rest of this presentation is to let you know what some of those options are. And more importantly, what I hope I can do is help you think about the whole concept of guardianship in a different way. Because this isn't about whether or not someone is incapacitated or incompetent and can make their own decisions and someone needs to do it for them. This is about what is the purpose of the guardianship itself. In other words, what are the specific support needs that my loved one has? And is there a way for me to help them meet those needs, short of a guardianship proceeding and taking away rights? Because that is one of the fundamental things to remember about guardianship. While it may be necessary and may be very appropriate, guardianship does remove civil and legal rights from an individual with a disability. And so it's really important that we think about that as we make decisions trying to determine what we do going forward to help meet the support needs of our loved one. Another thing to remember about guardianship is a guardianship is a creature of the court, meaning that it is created through a legal proceeding in a court, working with a judge. So once that guardianship is created and put in place, that court will have oversight over that guardianship as long as it's in existence, meaning that on a yearly basis, that guardian has an obligation to the court to report on what's happening with the guardianship. The guardian has an obligation to report to the court if anything unusual happens during the life of the individual with a disability. And if the guardian ever decides, or the person with a disability ever decide that they want to change or modify that guardianship in any way, it requires going back to the court and getting court permission. And that includes things as simple as if you ever need to change guardian. So a successor guardian can't just be in writing and it just happens if someone is no longer able to fulfill their duties for whatever reason. It requires going to the court and asking the court to appoint somebody else. And that's usually not a big deal, but it can be. And it's just something to be aware of is, when we're working with a guardianship, we're not doing it in isolation. It's a judge and a court that are making those decisions, and it's not just up to us. So, like I said, when we think about guardianship, guardianship is, the idea that if someone can't take care of their needs, court appoints somebody to do it for them. Legally speaking, in a guardianship proceeding, what a judge is trying to determine is whether or not an individual is an incapacitated person. And that's the legal term, incapacitated. What's that mean? Well, it means that it's an individual that because of their mental or physical disability is unable to manage their financial affairs, take care of their physical or mental health, or provide for their food, clothing, and shelter. That's what the law says. The law says if someone is unable because of their disability to do one or all of those things, then it's appropriate for a court to appoint someone to make those decisions for that individual. A guardianship in Texas does not have to be all or nothing. We have a complete, or what's called a plenary guardianship, where the guardian does take all the rights, decision-making rights of the individual with a disability. But most guardianships are partial guardianships, meaning that the individual with a disability retains some rights, and the guardian is given the right to make decisions about other areas. Excuse me. We also have in Texas basically two types of guardianship. There's a guardian of the person and a guardian of the estate. And they're basically what they sound like. A guardian of the person is someone that's responsible for the day-to-day care and activities of the individual with a disability. A guardian of the estate is someone that's responsible for the financial affairs of the individual. A person can have both, a guardian of the estate and a guardian of the person, if it's appropriate, or they can have one or the other. Someone may just need a guardian of the estate to take care of financial affairs, but all other decisions they're okay making by themselves. One person can be both guardian of the person and the guardian of the estate, or they can be two separate people. So it just depends. And finally, guardianships in Texas, there is a procedure if someone has a physical issue or a mental health issue that results in the inability to take care of their needs for a period of time, there's a temporary guardianship process in Texas. We're not going to talk a whole lot about that, but I just wanted to let you know that it exists. So speaking of the process, generally speaking, the way guardianship works in Texas is that if my family decides this is something we want to determine is whether or not our loved one has the need of a guardian. So first thing we do is hire an attorney, because in most courts in Texas, in order to file a guardianship petition, you've got to be an attorney. So you hire an attorney, and that attorney is going to file an application for guardianship in the court that handles guardianship in the county where the individual with the disability lives. So it's county specific. It starts where the person with the disability lives. The application's filed. Along with the application, there's also a medical report that's filed, and that report's called a Certificate of Medical Examination, and it is a report from a medical doctor, or in some instances, a licensed psychologist, that lets the court know, in the court's opinion, what are the decision-making skills of the individual with a disability. What are their support needs? What are their physical needs? Is their physical condition likely to change over time? So should the court schedule a rehearing or looking into the case at a specific time, or those sorts of things? So once that's filed, the court's also going to appoint an attorney ad litem, which is the attorney for the individual with a disability. Their job is to represent what the individual with the disability wants. The court will usually also appoint a guardian ad litem. And that guardian ad litem's job is to figure out, based on all the evidence and talking to all the people and all those things, what is in the best interest of the individual with a disability. So once the guardian ad litem files a report with the court, there's a hearing held. The person with a disability may or may not be present, depending on what's appropriate. Evidence can be submitted, witnesses can be called, and at the end of the day, the court makes a determination whether or not, based on the evidence presented, that the individual with a disability meets that definition of an incapacitated person. If they do, then the court determines which rights the individual, if any, the individual with a disability retains, and which rights go to the guardian to make decisions about. Once that's done, the court will then appoint a guardian. Once the guardian is appointed, especially this is, we're talking about the guardian of the person, like I mentioned earlier, a report has to be filed on an annual basis. That report is to inform the court about what's happened. It's a status report. What's happened in the life of this person with a disability over the last year? Do they have a job? Do they volunteer? What's happening with their health? What's happening with their finances? And that report is really important, because that is what the court uses in most instances to understand whether or not there's a need to investigate something about this guardianship and this guardian or this individual with support needs, or is there a reason to have a hearing and look at restoring certain rights, all those kinds of things. So it's really important to happen. One of the other things that I will mention, since we're talking about filing reports, and by the way, most of the time an individual, a guardian, can file their annual report without the use of an attorney. Now, lots of us attorneys want parents or families to come back to us to file that report because it means income, but it's not always necessary. So just a plug there. But along with that, I will say, when you think about guardianship, you think about attorneys, because there are attorneys involved in filing for guardianship. We talked about the attorney for the family, or person that wants to be a guardian, the guardian ad litem, the attorney ad litem. But whenever you have lots of attorneys involved in something, you know what? It costs money, because attorneys mean money. So I say that only to say that one of the big issues that several years ago, when a group of advocates and parents of people, adults with disability, and probate lawyers and lots of other folks were talking about the guardianship system in Texas and ideas about improving it and making it work better for individuals with disabilities and their families. Aside from the obvious real concern we had that we knew lots of people that were put under guardianship that probably didn't need to be, there was the discussion with families about cost. The average cost of a guardianship in Texas is between $4,000 and $7,000. And for lots of people, that's a lot of money. For me, that's a lot of money. And so one of the things that we tried to do through this concept of guardianship reform in Texas is try to figure out what is the purpose of guardianship. And once we figured out what the real purpose is, then our goal was to figure out, are there ways to meet those goals without requiring lots of attorneys and lots of legal stuff and lots of expense. And so this concept of guardianship reform was formed. And so guardianship reform in Texas is based on this concept of person-centered thinking or person-centered planning. And some of you may be familiar with those terms, but it's the idea that a person is a person, and a person isn't a problem that needs to be fixed. A person that has significant support needs is a person that has good stuff and bad stuff and all kinds of stuff. But one of the things they have, like we all have, are support needs. It just may be that the way to meet those specific support needs of that individual are different than it might be for you or I, but it's still, that's the question. And I didn't say that very well, but when you think about guardianship, think about this. This is what guardianship is really about. Remember that in Texas, guardianship is trying to figure out whether or not someone's incapacitated. And that means, can they make decisions about their finances, their health, and their food, clothing, and shelter? So their support needs. So that the real answer to the question is, what's guardianship about? Guardianship is about helping an individual that has needs meet those specific support needs that they have. So our concept of guardianship reform in Texas is based on this idea of what are the specific support needs of this individual and how do we meet them? But when we're asking those questions, according to the person-centered thinking idea, we're not only looking about what's important for a person, so taking care of finances and providing food, clothing, and shelter and those sorts of things, but we're also looking about what is important to them. What do they care about? So yes, they need to live somewhere, but do they want to live with a roommate? And if they want to live with a roommate, who is that roommate? Or if they need to make money, maybe they're getting money from SSI, so they don't need to work, but they want to volunteer. Where do they want to volunteer? What is it that they want? And those are the kinds of things that should be asked and taken care of when we're talking about those things. So anyway, guardianship reform happened a few years ago. And if nothing else, I want you to take away this because I think we're out of time. The legislature directed the courts to, when looking at that question of whether or not someone's incapacitated, a court has to make a finding that even with alternatives to guardianship and supports and services being used, that a person is unable to make decisions about their finances, their health, and their food, clothing, and shelter. So the big paradigm shift in Texas is that now in a guardianship proceeding, it's not enough just to say that someone has support needs. We now have to consider, are there ways to meet those needs short of appointing a guardian? And I guess I will end here. Think of it like this. The whole idea of guardianship isn't really the idea we should be thinking of. It should be, the question we should be asking is, what are the support needs of our loved one with a disability? And think of a continuum. On one end of that continuum is someone whose support needs are so significant, the only way they can appropriately be met is by having a guardian. But for lots of other people, maybe their needs aren't that significant, or maybe their needs can be met with a less intrusive way than a complete guardianship. Maybe they just need a limited guardianship or a guardian of the estate, and they can take care of all their other needs. Or maybe they need more support than that, and they need something like a power of attorney or a supported decision-making agreement to have someone assist them to make decisions, but they're still allowed to make their own decisions and don't lose their civil and legal rights. Or maybe they don't need anything formal at all. They just need to have a good relationship with a good friend that they can confide in, like I'm guessing a lot of us do. Because like I said before, we all have support needs, we just meet them in different ways. And so I'm gonna end because I'm out of time, and I apologize for not getting to the rest of the stuff. And I'm really happy to talk to anybody afterwards or at any time about this stuff. But when you're thinking about guardianship from now on, I really hope that you think of it in terms of what is the need that we're trying to meet? what it is about my loved one that makes me think that they may need a guardian. And are there ways we can do that short of taking away rights, going to court, and losing complete control? So thank you.
Say if y'all have questions, and it would be very helpful if y'all. These are all in Spanish. I'll email y'all.
I have a question.
Oh, yeah.
Got guardianship already. Of a minor. When you return 18.